Good afternoon, everyone, and thank you for joining us for today's event on other transactions featuring the newest member of the GW Law Government Procurement Program faculty, Professor Hallie Balkin. We are delighted to have her here today. We are also joined by Professor Victoria Christoff, who is also the Government Procurement Law Fellow here at the law school. So we are thrilled. We have a group in the room today. This is our first larger hybrid event. And so thank you to everyone in the room for joining us. And thank you to all of you who are joining online. We want this to be a meeting format because we'd like it to be participatory. We want to hear your questions throughout the course of the program. Once the program goes ahead and gets started, Professor Christoff and Professor Balkin will start talking about these issues and have a discussion, and then we're going to open it up for questions. I will be managing the question queue. So if you have questions at any period, just go ahead and put a Q in the chat function, and then I'll call on you. And if you want to come off mic for asking your questions, since this is a meeting structure and you have the ability to join us, we can actually see all of your squares in the meeting room right now. You're welcome to come on video and unmute yourself and join with the questions when it becomes time for you to join us. So with that, I will go ahead and get started with some introductions first. Since I didn't even introduce myself, and you're probably thinking, who is this person? My name is Jessica Tillotman. I'm the Assistant Dean for Government Procurement Law at GW Law School. And I am delighted to be joined today by first, Professor Victoria Christoff, who is the Government Procurement Law Fellow here at the law school. Prior to joining us at GW Law School, she clerked at the Court of Federal Claims and also clerked for the Federal Circuit. So she is joining us today and will be moderating today's fantastic discussion. Next to her, you have Professor Balkin, who is joining us from DAU, where she is all things expert in the area of other transactions. And truly the learning director for this area. You've probably seen her videos, you've seen her posts, you've seen all the information she's provided. She's really, truly an expert in this area. We are absolutely delighted that she'll be joining us this summer as a faculty member teaching our brand new course in other transactions. So we're hoping to learn a little bit more about that from you today. And with that, I will turn it over to my colleagues and we could go ahead and get started.
Thank you, Jessica. As Dean Tillman said, my name is Victoria Christoff. I'll be moderating today's discussion, and we're so excited to welcome Professor Balkin to campus. So just to give you a little heads up in terms of how the discussion will flow, we definitely want to hear from you all. And we know you all probably have lots of questions about OT, so we're going to save time for that at the end. If you could, as Dean Tillman said, for those online, just if you have a question, just put a Q in the chat function. That will save your place in line, and we'll open it up for questions. Same for the people here in person. But prior to the Q&A session, we're going to have a just general discussion about OTs, other transactions. We're going to be focusing on three buckets, I guess. We're going to start with the general overview. We have a broad range of people here today: students, government, industry. So we're going to, oh, there's an echo. Get into some general questions, and then we're going to get into some hot topics. This is a very popular contracting tool the government's been using. And last but not least, we would love to hear about your class. That's going to be starting this summer. So with that, given that we have this broad audience, let's just start off with the basic question. What are OTs and why? And let me say this, these OTs aren't new. The government's been using them since the 1950s, but we have seen an increase in them recently within the past, I don't know, 5-8 years. So what are OTs and why are we seeing an increase in them by the government?
Yes, absolutely. And thank you all for having me. I'm so excited to be here. Jumping right in, OTs are one of these tools that are more dynamic than a traditional FAR-based procurement contract. So oftentimes when I'm asked, okay, what exactly is an OT? I like to give a little bit of a spiel of what it's not. So it's absolutely a binding contract. There's a myth out there that it's not a contract. And I think where that derives from is that it's not a procurement contract, which is of course one of those terms of art that means FAR-based, the Federal Acquisition Regulation. If we're talking DoD, the DFARs, agency supplements don't apply to OTs, but other transactions are legally binding contracts. They're not grants, they're not CRADAs, they're not cooperative agreements. They are not subject to Competition and Contracting Act or CICA or the Contracts Dispute Act, but they are legally binding contracts. So one of the reasons that they are so popular right now is because OTs really allow us to emulate what the private sector does, what industry does, because we're allowed to be much more flexible. We're allowed to have frank conversations, negotiations. We don't have the big, thick set of rules that the FAR and the DFARs and all the other supplements entail. And it allows us to be much more expeditious with those negotiations if it's done properly. So it's not a fix-all, it's not a government solution to start pivoting all of our strategies to only use this, because there are some rules of how it has to be used, and Congress did provide those to us. Part of the reason that we're seeing much more expanded use of OTs right now has to do with the 2015 NDAA. So prior to 2015, Congress gave the Department of Defense authority to use OTA for weapons and weapon systems, which is pretty narrow. But since 2015, the Congress enacted language that allows us to now use prototypes that are directly related to the systems, the platforms, mission effectiveness, or to improve those systems, platforms, mission effectiveness. So if you think about what requirements a government agency might have, especially in the Defense Department, it's pretty broad. A lot of it does fit into that bucket. I do want to mention, though, that it's not appropriate for everything. So I've had clients come in the past when I was sitting in the Office of General Counsel with Department of Navy, come in and sit down and say, all right, I am so sick of the FAR. I'm sick of the vendor lock, the sole source contract. My vendors always delivering late. They're so expensive. I hear OTA is the coolest new tool. I'm going to pivot my whole strategy to that. And my next logical question would be, sir or ma'am, what is different about this requirement? What is different than what you've been doing in the past on your FAR-based procurement contract? And sometimes the answer would be, well, nothing. I just want to do something different. I want to do something faster. And unfortunately, in those instances, it wouldn't be appropriate, because we do have a quasi two-pronged test definition that GAO gave us in 2018 in the Oracle decision that essentially looks at what the government is trying to obtain and says, all right, has it been done and that technology been utilized in the government before? If the answer is no, okay, let's look DoD-wide. Has it been utilized in a similar way anywhere else? And if the answer is no, that means it could be a proper prototype. But if it's something that the government's been purchasing or acquiring on a traditional vehicle and nothing's changed, nothing's different, nothing's new, it wouldn't be appropriate.
Yeah, no, that's definitely a great background to this. And it sounds like these are a hot ticket item. There's a lot of flexibility that the government and industry can obtain through using prototype. Well, OT agreements in general, prototypes just one subsection of an OT authority. And you kind of hit on my next question. Given this flexibility and industry's interest in this, it seems that they could be used in a broad range of circumstances. So given that, what exactly, I guess, and maybe you touched upon it just now, but what exactly is preventing an agency from transitioning to the OT model instead of staying in the particular FAR-based model?
Oh, that is a very interesting question to address. Right now, we're seeing a lot of our workforce who are very savvy in FAR-based traditional contracting methodologies, very comfortable. They've been doing this type of contract for sometimes decades. And it's hard sometimes to take off that FAR hat and think in more flexible terms and think, what would make sense? What would logically be the best way to go about this process using those analytical skills? Because right now, the FAR and the DFARs and all the supplements give us a swim lane. We know our bounds. We have a lot of case law and GAO decisions that are published that kind of steer the bounds of how an acquisition can ensue. But in this kind of expanded world of OT since 2015, there's not as much. It's not as easy or as simple to maybe grab a template, kind of plug and play the new requirements, which can happen, and for good purpose sometimes on a FAR-based procurement contract. But for OTs, sometimes you have to start from a blank sheet of paper. Sometimes you look to what industry uses as an industry practice and what terms can we accept, which terms can we not accept. what makes the most sense? The cost structure can be completely different. We don't have any cost accounting system coverage, CAS, for our non-traditionals. So how do we ensure that the company that we want to work with is financially stable, financially fit? How do we know that they're utilizing their technology to the way we need them to? It takes these frank and open conversations, which is why I said at the onset, it kind of lets us emulate what industry does, because we get to have these conversations. And one of my favorite processes that you can do in an OT negotiation, and I'll preface it with, there's no one size fits all. There's no DAU prescribed method. There's no government prescribed method of how to engage in an OT and go through the process. But one thing that I really do like that we have flexibility to do is actually sit down with a vendor or vendors and have sort of statement of work collaborations where we say, okay, we need widget 1.0. And the vendor kind of sits there and scratches their head and said, wait, you want to let us opine on this? We're allowed to give you feedback. Normally the government just gives us the requirement and we have to say, yes, we can commit to delivering. But we can have these frank conversations where they say, okay, yeah, we have widget 1.0, but did you know that last week we developed widget 2.0? It's actually lighter and it fits in your system better. And we can actually manufacture it even more expeditiously. And then we're across the table, like minds being blown, because this is how work gets done efficiently. This is how we make sure that we're actually receiving what we need on the government side, but also that the vendor or vendors are actually delivering what we want them to deliver. Because sometimes the government is ambiguous. We have one requirement that we interpret as one way that another party or entity would interpret a different way. It's vague. And that leads to contract administration, which is expensive. But at the end of the day, the government's not getting what it needs. So having these frank and open conversations is just one of the really cool aspects if it's appropriate to engage with these companies.
Yeah, no, with that, I mean, that makes total sense why we're seeing an increase in this. It seems that more communication between the government and industry side could only benefit the process and make it more efficient, and getting the technology into the hands of the warfighters even quicker, hopefully. So I guess just touching on one more kind of general point before we transition to more hot topics, and this is going to lead into the next question. Can you explain, so there's these things called consortiums, right? Can you just, and they seem to pop up in the DoD context. What is a consortium and what role are they playing in the OT world?
Well, this is one of those very interesting cans of worms that I won't go too deep into opening. Sure. But a consortium is a separate entity that retains its own legal status that operates traditionally within buckets of industry. So you might have a space consortium or an underwater unmanned system consortium, something like that. And typically it's a body that requires members to pay some sort of fee. And the government essentially, what we're seeing is the government takes its requirement to a consortium in the subject matter that's appropriate and says, this is our requirement. And the consortium advertises and does a lot of the admin side of the house. We're seeing a lot of DoD entities especially utilize this model because DoD has a lot on its plate. There's folks who have a lot of different balls in the air, and it allows, from what I'm understanding, a more or decreased time frame of how to get the admin out, how to actually advertise the requirement, receive all of the respective proposals or white papers, and then the government is charged with actually evaluating them. Of course, evaluation of these types of criteria is a government function that's inherently governmental, so we don't want to outsource that. But then the consortium actually does the admin after that as well, and then cuts the award. So the government is actually contracting with the consortium.
Gotcha. Yeah. So it middleman might not be the proper term, but in some ways they're there to assist, to facilitate the award of OTs between the DoD and the actual contractors, right?
Yes.
If I'm understanding the process correctly.
Yes.
Right?
And I have had conversations with folks who utilize it, and they do explain that there is an economy of scale. So if you have an office that doesn't have a seasoned staff of folks who've engaged in OTs before, utilizing the consortium model could potentially help it move faster in terms of the admin.
Yeah, gotcha. Well, with that, and we're not going to open the can of worms, but we'll get near it. One of the first hot topics is this issue of transparency, and it comes up in the context of consortiums. In April of 2021, the DoD Inspector General's office issued or conducted an audit with DoD spending of OTs that have been awarded to consortiums. And some would say that the findings were at a minimum concerning. Two of the main findings were that the DoD didn't necessarily always follow the laws and regulations surrounding OTs when awarding these to consortiums. And the second finding was that just the tracking of spending was not sufficient, that there was uncertainty as to where the funds went. So transparency is a concern, at least when I read this report. And with that in mind, are we seeing these types of transparency issues outside of the consortium context, when not just maybe DoD, but because other agencies have OT authority when awarding OTs?
Not from what I've seen, but then again, I'm not engaged with every single OT federal government wide, but I will say that especially at DAU and the folks that teach and train the proper usage of OTs, we always state that transparency, reasonable, acting ethically are always the tenets of how we should engage in government business. Anytime we're utilizing taxpayer dollars, those should always be at the front of the agreements officers and the team working on the OT's mind. Any kind of contract should be. Is it always being done? I hope so. There's, I'm sure, always room for fraud, waste and abuse, which is why the IG got involved in their DoD IG audit. But I think the bigger question that the IG report kind of contemplated is, if the DoD, if we think about DoD for a second, if the DoD OTA guide standard for competition is maximum extent practicable in terms of who we're actually competing amongst. And if we think about kind of big picture, the government used to be the driver of technology. The innovation used to be done in the government labs. And that's just not what we're seeing anymore. Now we're seeing innovation done in places like Silicon Valley, Austin, Texas, here in DC. The innovation really is not in an in-house capability that now the government has to look outside government labs. We have to partner and to leverage these relationships with companies in order to maintain our competitive edge government-wide. So if we think about that context and we want maximum extent practicable competition, if we're awarding to a consortium and that firm maybe only has a handful of members or maybe more, are we really meeting the intent of expanding that competition, that awareness to vendors who might not view themselves as traditional defense contractors? Because if you're a traditional defense contractor, you've probably heard of a consortium. But what if there's a vendor out there that creates technology that company never really considered application for the government or the military? What if that technology could fix a huge problem for us and the government needs that? How do we reach them? So that's kind of one of the areas that we're seeing in terms of that transparency and ability to make sure that those consortia are kind of expanding the breadth of how they're competing into who even knows about the consortium model.
Yeah, totally. And picking up on what you just said in terms of how the dynamic has changed, the government used to be the one leading the way in technology. Now we're seeing these private, smaller firms, and people involved in this area of law and contracting are and for those who don't, the Valley of Death refers to the space between the research and engineering community and acquisition community. So we have these cutting edge technologies available oftentimes in small or non-traditional contracting firms. We want to get them into the hands of the warfighter, but there is the traditional FAR-based process and the funding process. So the time lag could let these technologies kind of just stay in what people have phrased the Valley of Death. Some would say OTs, especially prototype OT agreements, help bridge that. But yet we still see this Valley of Death. And so I guess with that context in mind, what do you tell contractors who are looking to break into this area? And I guess, how do they get into the prototype OT arena? And is it even possible or feasible? Is it easy to get into that environment?
Well, I can't speak for how industry can really break in because it's just not something that I've ever really engaged in. But I will say that taking 18 months to 2 years to get technology on contract is not is not working.
Mhm.
By the time we contract for technology and it takes 2 years to get that technology in the hands of a warfighter, it's obsolete. It's no longer relevant. There's probably several different things that now have outpaced that technology that we contracted for 2 years ago. So how do we fix that issue? OTs could be one of those ways for all the reasons that we've already discussed. If there's something new or different that hasn't been utilized by the government, this is a way for vendors to get in. I think the bigger challenge for us right now is not kind of paving the way for these companies to work with us. It's getting them interested in working with us, because the government, we have a reputation for being bureaucratic and slow and confusing and also very expensive to work with. Oftentimes these companies have to hire proposal writers who are savvy in government speak and acronym jargon and military focused articulation. And that can be really pricey. So if you're a mom and pop shop or you're a non-traditional vendor, meaning you've gained less than 50 million US dollar DoD dollars in the prior reporting year, you might not want to work with us. You might think that the government is not worth it, especially if you have a footprint outside of the government and you don't need government money. Now, it's so different from 40, 50 years ago, where the government was probably viewed as having very deep pockets, being an on-time paying customer. And now that's just not necessarily the only driver, because there's so much technology usage outside the government that these companies might not necessarily view themselves as a defense contractor because they don't want to be. Other times the intimidation makes it a little more difficult because we have the rule sets of the FAR and the DFARs, and again, all those other applicable supplements. So I think getting the word out and continuing to explain that the government can do business differently, and we are trying to, will help entice these vendors who otherwise wouldn't want to play with us. Believe it or not, LinkedIn and other social media fora have been really helpful in helping us identify some of these companies. I worked on a very large OT prior to coming to DAU that had a final price tag around $2 billion. And one of the coolest small businesses that I've ever worked with that had some of the most cutting edge technology, that when I saw it for the demonstrations, my mind was blown that we could actually do this. I mean, it was kind of like taking me back to what I watched in Star Trek years prior. But essentially, we found this vendor on a LinkedIn post that a very senior military official had tagged, and it kind of went around. And we were looking for a specific type of technology that this vendor had never anticipated government use for, because they didn't need to and they didn't really want to. But they came together with a couple other companies and made this pretty fantastic prototype for the government, and it's being used right now. So I think education, word of mouth, showing that the government can do things differently. It's just going to continue to kind of evolve how we're viewed, hopefully, and open up that aperture of who actually wants to work with us.
That's great. So yeah, so it sounds like the baby steps is really awareness and spreading the word and educating these firms that have not traditionally done business with the government. So
Absolutely, but also make sure the right information is out there.
yeah, that's
There's
true.
a lot of bad information floating around out there that can get some folks into.
DAU is a good source of good reliable information on OTs. Awesome. Well, another hot topic, and maybe it kind of relates to firms who aren't used to doing business with the government, could be a potential roadblock for them into coming into this arena, which is the topics of disputes between contractors on OTs and with the government, not just disputes on claims, but bid protests. Could you speak a little bit to, so if what is a contractor's, they think that they should have won the OT and they didn't, is there a way for them to file bid protest? What are you seeing? I know generally there's 3-4, the courts, GAO, the agency. So what have you been seeing? Is there a path forward for bid protests? I guess we'll start with that question.
Yes, this is one of those areas that has evolved ever since probably the 2014-2015 timeframe. So GAO traditionally will not review protests regarding other transaction authority unless it relates to the notion that a procurement contract should have been used in lieu of the OTA. So the protest allegation would be the government misused the authority because it was going OTA versus procurement contract, and it should have been a procurement contract. We saw cases like Morphe Trust and Oracle, and a few other ones that GAO was specific to. That would be the purview of what they reviewed. Moving forward a little bit to the Court of Federal Claims, there's also been some activity, SpaceX and MD helicopters, where it was also very specific to what the court would actually review. I will say it's not the easiest path right now to get a protest actually heard in one of these fora, but keep in mind that GAO is an arm of Congress. Things could change as Congress keeps continuing to review what we're doing in terms of utilizing it. But I don't think what Congress intends, and I couldn't speak for Congress, but my notion, and this is not DAU, this is just my own personal thoughts. I don't think that Congress wants OTA to become as complicated as the FAR, the DFARs, and everything else. Because if it does, then how are we going to get that technology faster? Now, there's a fine line. We can't abuse the process. We have to provide transparency where appropriate. We have to be doing the right thing. It shouldn't be kind of a blank check for an agreements officer to write a requirement for a vendor that it thinks is great without any kind of due diligence or competition. And that's not what we're seeing. And that's certainly not what the DoD IG audit kind of came out with when they brought their findings out in the report. But if we make it so complicated and so burdensome, especially in terms of litigation or bid protests, it could have a chilling effect on the use. And that's what we don't want. We don't want it to become so burdensome in terms of evaluation with a microscope, where agreements officers and source selection team members are, delicate in their crafting of a significant weakness and the justification supporting that significant weakness or deficiency or a strength. What we don't want is to make that process so similar that it again will become an authority that's lesser used. Because big picture, we need to rely on the partnerships with these companies. And it is a real partnership. It's shifting the mindset from government awardee. It really is a thinking partner, a partnership to bring about the technology that we need to utilize.
Well, that makes sense. Yeah, this seems like there's some tension at least in this realm of OTs, that we want transparency. We want contractors to feel that their rights have been vindicated and have their day in court, yet keep the process efficient and not bog down litigation. So finding that balance is, it's hard, but it sounds like there is some way forward, and there are some for us for filing bid protests.
I just want to add one more thing,
Sure.
Victoria. Yeah, I have had a lot of folks and clients in the past and customers now come to us and say, all right, we have a request for a post-award debrief. We know FAR Part 15 doesn't apply. Do I have to provide one? And I think that's a really interesting contemplation. And traditionally, my answer would be, well, what happens if you give them a debrief? What's the risk, really? If you're talking about a non-traditional vendor that spent X amount of months preparing for this potential OT that they were unsuccessful in obtaining, would it foster a better relationship to let them know what went wrong? Or maybe they were expensive, or maybe the technology just wasn't right to meet their requirement. What harm does that really entail? And I don't think in most instances it's much harm, because if we can provide that feedback, the vendor is going to grow. The entity is going to learn from it. And then maybe next time they see a requirement for an OT or a government requirement in general, maybe they'll have a better feeling about, what, I had closure from the last time. I want to work with the government. I think that maybe this could be a potentially good relationship. Versus if we just ignore the vendor and never respond to them, which also happens. They're going to think, well, what was that for? I spent all of this time and all of my company's resources, and we're a small shop, or we have a not that big of a government enterprise to do this, but they're just going to ignore us, or they're just going to say no, or they're just going to say you are not the successful bidder. I mean, what kind of relationship does that foster? So what if they come out with technology that's even better the next iteration? Are they going to want to work with the government? Yeah. Probably not. So I do think it's a balance, and not to say that you should always provide one of these summaries, and I would avoid calling it a debrief because it's a FAR-based term. But if feedback, what harm does providing feedback really look like? And maybe it is more harmful. Maybe you have a very litigious entity on the other side that, maybe opening that up would be risky. It should always depend. Your specific requirement that you're contemplating will always drive what your strategy is. And that goes for every OT, because no OT will be alike, since they're all going to be, new novel areas of or applications of technologies or things. But we should always look at the specifics for each requirement.
That's a great point and great advice. And, sometimes people can see debriefs as a fishing expedition, right, to file a bid protest, but oftentimes it could prevent a bid protest if they get sufficient information. They really see, oh, okay, well, we just didn't meet the requirements. So, and in terms of this area of contracting, it seems that fostering that open communication will bring more people into this field. A related point, if you could just briefly talk about what if a contractor has a claim against the government? So they already have the OT and they think there's, a breach or an outstanding claim that the government's not going to want to pay or not going to pay. What's their remedy? Is it similar to what would occur in a FAR-based contract, or is this also something that makes OTs different?
Yes, this is done a little differently, but depending on the agency. But what we traditionally see is that agencies are setting forth the terms for conflict or potential challenges up front in the contract. So sometimes there's ADR, alternative dispute resolution methods set forth in the contract that each party agrees to. Since we know CIGA and Contracts Dispute Acts don't apply, it really is traditionally going to be based in the industry area. If there's, let me back up. Contracts can be structured in various ways, as we all know. I think the cleanest way to do it is a fixed price delivery arrangement where each deliverable has its associated price tag. Now, in a perfect world, that'd be great, because then everything that's delivered, we have a price tag for, and the vendor or vendors receive payment when that delivery is successfully made and accepted by the government. But what happens if the technology never ripens? What if that delivery can never be made? That's where we get back into what the contract actually states, because maybe there's no recourse. Maybe there's a risk on the vendor to develop this at its own expense. Maybe not. Maybe there's a cost share type arrangement. Maybe there's something else unique to that specific space. It's hard to give a kind of a catch-all answer because it really will always depend. And I do always recommend folks meeting up front before the two parties sign to make sure that everyone understands and is comfortable with the terms, because it will be different case by case. I will say it also really is different if it's a commercial type technology versus something that's being developed. Maybe going a little bit into the weeds on one point, but I think I'd be remiss if I didn't mention it. If there's commercial technology out there that already exists, that you can go on Amazon.com right now or BestBuy.com right now and purchase it for your home PC, and you can get it uploaded and installed on your computer today or tomorrow. If that's never been utilized in a government system, let's say the Navy system, NMCI, if that's never been done on NMCI, that could potentially be a proper prototype. Maybe just a few changes to make it compliant with the Navy system, but that could potentially have huge impacts. So what if there's recourse for commercial terms? That would be very different in terms of if something that's being completely developed that's not commercially available for the government. So all those considerations would most likely come into play in those scenarios.
Great. Well, I have one more hot topic before we transition into your course. This past fall, the DoD issued its Climate Change Action Plan, which is aimed to ensure that the DoD is mission ready even under changing climate conditions. And one of the goals of this plan is to continue with installation resilience, which is military installations are trying to put in place measures to help combat climate change or environmental changes, such as wildfires, erosions of shorelines, removal of hazardous fuels. And currently, the DoD can do this through a variety of means: cost share agreements, cooperative agreements. And we've had some people from the Hill kind of raise this question of whether, apart from these tools that are already there, can the DoD potentially rely on its prototype OT authority to help in this mission of installation resilience? And just curious about your thoughts about that.
Yeah, I think it's absolutely a possibility. The DoD or the NDAA that Congress gave us in 2015 really opened up how we could utilize OTs for things that haven't been done before. As long as it's directly related to the systems or the components or materials or supported platforms, I think the argument could be made. It would be incumbent on the agreements officer, the professional who's responsible for signing the contract, the OT contract, for making that determination, and the standard is reasonable. Is it reasonably directly related to those types of things? But yeah, I think there's a lot of application for how it's used. I mean, if we look at just in the last couple of years, the COVID vaccine was utilized on an OT. So that was done on an OT contract. So we're seeing novel applications of emerging technology or capabilities done. And as long as it's reasonable, I don't see why that would be a challenge.
Yeah, I think you raise a good point that the statutory authority for DoD's OT prototype authority is written pretty broadly and flexibly. So yeah, that makes sense that there seems to be some room for use in that. Just in our last few minutes here, transitioning now to your class, which starts this summer at GW Law School. And we're so excited to have you teaching this class. It's open to our students, JDs, LMs, MSLs. And to kind of just get everyone oriented to it, what will your class focus on? And I guess follow-up question, if possible, just give us a brief overview of what the class will be touching.
Yes, I'd be happy to. I'm very excited. It has been my brainchild the last several months. The class will cover what types of efforts are appropriate for OTs and what aren't. A lot of times you'll be sitting in your office and you'll get a client comes in, like I mentioned before, and they want to pivot their whole strategy to OTs. Is it appropriate? Is it not appropriate? What considerations come into play? If it is appropriate, what's the best way to structure the contract? We don't have the DFARS data rights rules to rely on. So what kind of data rights are going to be associated with the effort? What color of money are you talking about if it's a DoD contract? What other rules and provisions should the contract entail? So the course will include a lot of these hypothetical clients coming into the students, and the students will act as the counsel, and they'll provide guidance based on developing issues that we're seeing right now with OTA. They're going to be really diving into some of the more nuanced areas. So the students leave the class with that knowledge of how to actually utilize it or provide guidance on how to utilize it, or both.
That's great. It seems very practical, very timely, and interesting for sure. For some students who are wanting to enter into this government contract field, why should they take your class? Why is the study of OTs important for them in rounding out their government procurement studies here at GW?
Yeah, if we look at the sheer volume of what the federal government is spending on OTs, it's certainly not a trend that's going away anytime soon. I have heard that myth that it's a trend and, I'm not going to waste my time learning it because I know we'll go back to a cost type contract afterwards. The government's not abusing this authority. That's not what we're seeing. So since we're not abusing it, and it does have such impact and potential benefit, it's important to know all the different tools in your government acquisition toolbox, because if you have a client come in or you're working on with a customer that wants to do something like this, they need to know what rules apply, what don't. I also think it's important to know all the other types of tools, because OTA is not going to replace FAR-based contracting. It's not going to replace procurement contracts. So understanding the differences of when one is appropriate or when both could be appropriate or when one's not appropriate, alongside bailments, corporate agreements, grants, CRADAs, all the other different types of contractings that exist out there, helps the student be more well-rounded in what federal acquisition really looks like and what's available as a potential contract vehicle.
Awesome. And excuse me, just for students who are, we're in their registration period right now. Just to learn a little bit more about your background, how did you become a subject matter expert in OTs? Because it seems you know a lot about this area.
Well, I would be remiss if I didn't mention my predecessor, Diane Sidebottom, in the audience right now, because she, when she left DAU to go to DARPA, she had left a very large pair of shoes to fill. I was a Department of Navy attorney sitting in a program office, and I had a client bring this to me and say, I want to use this authority. And I kind of just was exposed to it and jumped right in. And I will be completely transparent with you. I was a skeptic at first because I was wearing my FAR-based hat. And I said, what do you mean we don't have automatic government purpose rights for the situation. I mean, it was hard for me to get into that zone where I didn't have those comfortable bounds of what I knew and how I operated. And I quickly became a believer. I really saw the goodness of what could derive from these OT contracts and getting the warfighter this technology that we otherwise would not be able to obtain.
Great. Well, awesome. Well, thank you for that. And with that, with these last few minutes, we would love to open it up to questions from the audience on Zoom and to anyone here as well.
Okay, so for anybody in the room, we have a mic for you because it'll pick up the phone. Not the phone, this would be a microphone. So you can ask questions this way, you just need to turn it on. And then I know we have a bunch of questions that have come in the chat. So I'll go ahead and man that, but I have a question in the room that we're going to get started with, Allison.
Hi there, thank you so much. It was a very interesting presentation. I'm Alison Anthony and I'm a research scholar, visiting scholar from University of South Africa in public contracts. And in South Africa, you'll see I posted it in there. I wasn't quite sure how we're going to deal with questions from the room. But in South Africa, we are always trying to find alternative ways of contracting with the government, simply because open contracting is just so expensive. Time consuming. It's a very onerous process full of documentation because we haven't progressed to the stage of effective e-procurement just yet. So I wanted to know in terms of other transactions, are there specific types of procurement, specific types of goods, services or works that are best suited to these other contracts? It's a completely new concept to me, so sorry if it's a very simplistic question. But I'm also still learning the US procurement system. So would there be specific or unique types of things or works or services that are best suited to other transactions?
Yeah, thanks for the question, Allison. And I feel for you in trying to learn our government procurement system because it is complex. It can be confusing. We are seeing quite a bit of goods and services being utilized under other transactions. We're seeing a lot of commercial technologies, a lot of software, a lot of cloud-based computing systems. But as I mentioned earlier, we also utilized the vaccine development. The contracts with Pfizer and Moderna were done via OT. So we're seeing kind of the whole gamut of what's being done. The kicker is just making sure it really is appropriate, that it's either a proper research or prototype OT.
That sounds pro-innovation.
Yes. Yes, as long as that innovation hasn't been utilized in the government before. So if you and I kind of were sitting down for a cup of coffee and contemplating what prototype meant prior to 2018 in a government construct, we might think of something super secretive and cool in a lab that the world's never seen. But with the Oracle decision that came out in 2018, we actually saw that wasn't the case because the kind of quasi two-pronged test they gave us really looked at to whether it had been done on a US federal government system before. So even though something might be commercially available or maybe developed in South Africa, if that technology has never been put on, say, a US government system, that could still qualify as a proper prototype.
So the first question from the chat, I see Timothy. If you want to go ahead and unmute yourself, you can go ahead. Timothy Manning, you can ask the question.
Sure. Thank you very much for the time today. I have a question regarding cost share. Have you seen instances where a contractor may have used cost share as part of an OT agreement as a basis for future commercial item determination? And if you haven't seen that scenario, would you have any comments about potential pitfalls? And again, thank you for your time.
Yeah, so that's very specific. In terms of cost sharing, we're seeing quite a bit of cost sharing arrangements in contracts where the vendor is traditional. Because one of the ways that the government awards to a vendor or a group of vendors is by requiring that traditional vendor, meaning they've received more than 50 million of government dollars in their prior reporting year, actually is required to bring 1/3 cost share to the table. So pitfalls, advantages, I don't know if I can really speak to that because it will always depend on the circumstances, but that is a routine way of contracting that we're seeing the government engage.
Thank you.
Thanks, Timothy. Tim asks, at a legally binding contract, do statutes like the Small Business Act, EEO, Davis-Bacon, et cetera, apply even though the FAR does not?
So Small Business Act, yes, applies. That applies similarly. Fiscal law also applies similarly, the same way it would to a FAR-based contract. Another one that is up for debate often is Buy American Act. Buy American Act generally does not apply to OTA, but there are some instances where it will. And it will depend on the requirements. So some requirements, no matter what, will always be subject to Buy American. And an example of that could be a military uniform. Those are always subject to Buy American. So it will depend on your specific requirement. Everything else, for the most part, is negotiable. Sometimes we have vendors insist that certain acts or rules will apply, or sometimes we have the government insisting that a certain act or rule will apply. And even if the statute doesn't require it, it really is incumbent on the parties to come to that kind of middle ground to make sure that they're both comfortable with what is actually executed in the contract.
So I as a follow-up to that, I know that when contractors are trying to determine what clauses are flowed down, that there's a similar situation, which some are mandatory flow downs and some are negotiable, depending on the agreement between the prime and the subs. So is there a guide or anything or a place where somebody that's interested in OTs or interested involved would be able to find out which statutes are mandatory and which are negotiable?
There is a memo that came out, I think it was 2005, like a very, very, very long time ago, that tried to tackle that question. And I don't know how updated it is, but what I recommend is taking a look at what is consistent in the industry in which you're operating. What does industry standards look like? Obviously, the government's not going to adhere to a choice of law in the state of Texas because the federal government abides by federal law. But if there are certain rules or statutes or protections that one party really wants in the contract, whether it's the government or not, it really would depend on the specific requirements, but then again, what everyone else is comfortable with signing.
This feels like a research project for a student to develop a guide. So Don, hi Don. The misconception is that this is a prime sub relationship, consortium management firm performing vendors. Can you talk to this?
Yes, open that can of worms a little bit. So the consortium management firm does not actually perform the requirement. So in a subprime situation, the prime has to complete the work to a substantial amount. That's not the case here. The consortium management firm really is managing the contract, not performing the work. And I will stop there.
We have more questions in the chat. Real quickly, I want to make sure, does anybody in the room have a question so that I'm not ignoring you? Our wonderful hybrid group. Al, hi Al, states that getting contractors interested also includes soliciting in places where innovative firms look for business. SAM.gov is typically not the best source for this.
Yeah, absolutely. So the central point of entry for government business tends to be SAM.gov, but who knows about SAM.gov? The traditional vendors, the vendors who want to be defense contractors or already are traditional defense contractors. So how do we engage with those who are not traditional? LinkedIn, social media is a good avenue, but also trade journals, conventions, seminars. I know there's huge events like South by Southwest, where I saw a lot of my colleagues meeting with industry folks that would never have thought about sitting down with someone from the government to discuss technology or utilization. SAM.gov is something that we always encourage. Doesn't mean that you shouldn't. Having a SAM.gov posting probably couldn't hurt. It doesn't take that long to post, and it could help foster some of those relationships with traditional vendors. But I always recommend not relying simply on SAM.gov. So thanks for the comment.
And for those that have just joined us late, I've seen some questions about who we are. I'm Dean Tiltman, Assistant Dean for Government Procurement Law at GW. Professor Christoff, my name, I almost forgot my colleague's name. Professor Christoff is a professor here at GW and also the Government Procurement Law Fellow. And obviously this is Professor Balkin, who'll be teaching the other transactions course offered this summer online. So people sometimes ask about that too. Okay, how does OTA differ from the Rapid Fielding Initiative RFI that was used to get new kit to warfighters during OIF? That is a lot of acronyms.
So RFI, request for information, if I'm
I
understanding
think
that.
he's rapid fielding initiative.
So,
Anybody?
oh, middle tier acquisition. Okay, mid-tier is a, thank you, Diane.
Thank you,
Mid-tier
Diane.
acquisition is one of those contracting strategies, methodologies that can work alongside OTA, but they're not synonymous. So mid-tier can use FAR-based contracting or OTA depending. That one comes up a lot. Folks think that they have to be used together, and that's not accurate.
All right, Rebekah has a question. Rebekah, if you want to unmute and you can go ahead and ask.
Hi, thanks for the information. I have two questions. One, with the SAS direction to conduct a PPPE commission to look at how budgeting is done, do you anticipate that OTAs will kind of go out of favor if that commission comes back with more lenient ways to bring these smaller companies online? And then two, do you think that there's any clarification that Congress needs to provide to the Department of Defense related to the use of OTAs to make them more effective?
Okay, thank you for your questions. The first one, if we require non-traditionals and small businesses to do things like obtain cost accounting system that we can go in and audit, yes, I do think that would have a chilling effect on who wants to work with us. I was engaged with an agency who shall remain nameless that wanted to include a lot of audit capabilities in the contract, and they wanted a lot, if not all, of the costs proposed to be auditable and traced and kind of analyzed in a traditional way. And there were several small businesses that regretted to actually bid on the effort, because I do think that when we treat vendors like traditional contractors who have entire shops set up to do these things, we do miss out on capabilities because we're putting so much administrative burden on that small business or non-traditional that might not know how to comply, let alone have the capabilities to comply. The second question, what should we do to demonstrate to Congress that we're utilizing OTA correctly? I think that was the question. Or what can we give them to show with granularity that the government, I use we a lot. You can tell my audience is normally government, that the government is utilizing the authority in the way that it should. I think transparency is always the way to demonstrate that no one's trying to hide the ball. What is it? Sunlight's the best disinfectant. I like that phrase. I think that showing that we're taking taxpayer dollars and sometimes in huge amounts. And if you look at the latest fiscal year of how much the government is obligating to OT contracts, it's astronomical. And I think the more we are able to share what we're doing, what our process is, to the extent that it doesn't open up other challenges that would potentially have chilling effects or minimize that use, I think it's a balance. But I do think that the government having trust in the government spending is always a good thing. Does it always happen, and will it happen? Probably not. There are areas that we can't disclose. There's areas that involve trade secrets and security matters that we can't publicize. But I do think being transparent and sharing information where we can, especially in those instances where we get an unsuccessful vendor coming in and asking for some sort of follow-up information, will continue to foster the trust that we are trying to do the right thing and we are trying to be as transparent as possible. Right now, contracts over $10,000, I believe, are to be reported into the FPDSNG portal. So Congress does have a pulse on what we're spending in that avenue.
I suspect Rosa's asking something that I was thinking.
Transparency.
Those of you who know, I teach the anti-corruption class, so I have thoughts.
Thank you for being here today. And just to follow up, there's a question about transparency. Do you feel like the portal that's being used now is a good way of reporting other transactions, because it seems like it's tailored mostly for FAR-based contracts? And also, based on your experience and what you've seen in the field, do you feel like the government does a good job with transparency for other transactions? Seems like there's a lot of misreporting going on, and what the government can do better.
Yes, thank you, Rosa. I'm not involved with any of the reporting concerns that you're mentioning, so I can't speak to that. But I will say that if I could tell you how many emails I get from folks in the defense acquisition workforce stating that they have to do contracts in a certain way because of the FAR-based contracting writing system, and that's the way it's set up. Gosh, you'd laugh. Yeah, I think there's a lot that can be done. If we are really trying to utilize OTs as a separate swim lane, I think having different measures, perhaps for reporting, perhaps for contract writing, would be really beneficial. Will it happen? Probably not anytime soon because it's expensive and we're the US government. New systems and getting authority to operate takes a lot of time. The ATO process is extremely frustrating for some agencies because of the timeframes involved. So if we could have tomorrow a new contracting writing system that automatically reported all of the spending to Congress, I think that'd be incredible. So maybe that's a challenge for anyone out there in industry who has some sort of technology or business platform that can help us do that faster, because I think that really would benefit. Will we get there? I hope so. I hope that we're able to report in a more transparent and expeditious manner, as opposed to that FPDSNG system that really is associated with FAR-based procurement contracts.
Butch commented that this is helpful because they're considering this model with their work in NATO. So, hooray.
Yeah.
I think-
I was involved with a NATO Nile effort for a system that did contemplate OTA as well. And I think having the flexibility of not necessarily always having Buy American applied opens up foreign partners, foreign companies and technologies that could be developing that we could utilize successfully here.
I see a hand raised by S. Milan, whose name I may have mispronounced.
Yes, I just had a brief question. I assume that OTA isn't solely the domain of DoD, but other agencies have statutory authority in the appropriate circumstances for OTA. Is that true?
That is true. There are 11 agencies that have other transaction authority. HHS, Interior Department, NASA has authority, of course, being the original utilizer of OTA during the space race in response to Sputnik. Yeah, there's 11 different agencies. NIH has authority as well.
Are they prevalently used by those other agencies or rarely, if you know?
I think they are being used. I really can only speak to a DoD and a few other three-letter agency uses of it that I've been involved with, so I can't really speak to a few of the other ones, but Health and Human Services, HHS, was involved heavily with the Operation Warp Speed initiative with the Army and the White House Office of Science and Technology. So we worked with them there.
COVID was what agency? HHS?
HHS alongside the DoD, Army, and yes, Diane Seibbaum has my predecessor.
Sorry, I came up with this a little bit.
Yeah.
Well, thanks.
Different agencies have different versions of the OT statute, so they're not all the same. DoD and DHS are the only ones that have the prototype authority. Most of the rest have research OT authority, and then NASA does more OTs than anybody, but they do it in a totally different way because they don't take money, they don't put money out, they only take money in through the OT authority. So they're all a little bit different. DOE has the authority, transportation has it, but from pipelines, there's a lot of different variations on it. So you can't put them everybody in one bucket and say, oh,
Yeah, perfect. Thank you, Diane. And also DoD is the only entity with color of money. So the spending is much different when we see those agencies utilize it versus what DoD goes through. Thanks for the question.
Can you talk to the type of funds, color of money for OTs? Did you just say that?
There we go. Perfect timing. And I didn't even have these in advance. Yes. So we hear all the time that RDT&E research type fundings have to be utilized within DoD. So again, only DoD has colors of money associated with their spending. That's not true. So you don't have to use one specific color of money. Is RDT&E type funding used the most? Yes, that is what we're seeing when we look at what actually is being expended. But it should always depend. So the theme for today, if there's anything you take away, I hope it's this, that every single requirement has specific unique qualities. And so it really will always depend on what you're trying to do. So if you have, say, commercial technology that you're utilizing RDT&E to get it onto your system, but then there's maybe a commercial license associated with that technology, maybe O&M type funding, operation maintenance funding would be appropriate, maybe a hybrid. So I really recommend always engaging, if you're a government, engaging with your whole team, your finance folks, your BFM shop, your program folks, your attorneys, of course, at the very, very beginning, your engineers, your logisticians, everyone, to make sure that you have identified what your requirement is, and you can articulate that to your finance folks so they can help you identify whether you A, have that appropriate color of money, and B, whether it's actually appropriate. So you need to make sure that all of those are aligned before getting too far into the process.
Butch asked, what are your top 3 recommendations to get smart on OTAs? I would say your number 1 is that you could enroll at GW Law
Yes,
School in the government
absolutely.
procurement program. As a student, we offer degrees for lawyers and non-lawyers. We also offer some courses, including the other transactions course, on a non-degree basis. So you can enroll in those courses up to 6 credits. And then I'll actually turn the question to the person it was directed towards.
No, you read my mind, Dean. So absolutely, this is the number 1 what you should do. No, all kidding aside, I'm really excited for this course, and I really look forward to having as much engagement as possible, because like I mentioned at the very beginning, the more information that you all have, that's the right information, albeit I don't know the answer to everything, but I will help you get there if you have a question that stumps us. But we want this to be utilized in the most broad way possible, because at the end of the day, it's what our government needs. It's what we need. We need this emerging technology. We can't keep up with the pace with our adversaries by doing what we're doing. So how do we keep using it? It's educating, experiencing what these efforts could look like in a hypothetical situation. Not to take the light away too far from GW, but DAU, we have a lot of webinars out there as well that you can access right now without any sort of account or enrollment. My predecessor, as I mentioned, is in the room. She has a lot of videos that we kept on our DAU OTA channel because they are just relevant, they're concise, and they're chock full of information that you should have. We DAU have a monthly webinar series where we engage with industry, we engage with academia, we engage with judges and GAO attorneys sometimes to talk about these hot topics. And we try to do it about once a month. So you can follow me on LinkedIn, and I post everything there. The series is called OTA Today, and it's also available. All of our recordings are available to the public. Anyone at large can access them on our DAU media channel.
I will also note that I think the DARPA website has like a bunch of resources on it as well. And in fact, one of the links to it, for those of you that are really new, if for the lawyers that have joined us today, or the law students that have joined us, there's a really nice briefing paper that one of our adjunct professors here has written on it, kind of explaining the difference to help people really get a foundational understanding between the two. So if your background is in FAR-based contracts or you've been learning it in school, it's a nice little transitional resource I'd give a little plug for.
Yeah, that's good to know. If we could, I'd love to put that on our DAU page. So it's all in one place. That'll send you the right places, but then you
DARPA
can have
site
one
has
central
it.
belly button to go to DARPA, to go to this paper, just so you don't have to search everywhere. Because I know there's a lot of information out there, and trying to decipher what is good information, what is not as good information, I know can be a challenge.
Yep, that's great. And with that, I'm just make sure I'm not forgetting anybody. Actually, I think we're actually out of time, and I'm so sorry. We're going to go ahead and put this recording onto our YouTube channel, but I want to take a minute to thank everybody for joining us today. For those of you in person, it's delightful to see you in person. For those of you that joined us online, thank you for joining us online. It's been just such a pleasure to have you here. And of course, thank you to our incredible moderator today, Professor Christoff, and to our, obviously, the star of the show, Professor Balkin. We're so excited for your class this summer. So thanks, everyone, and thank you.
Thank you.